Welcome to Module 1 of Practice Management Business Operations. So this module is all about the business side of running an architecture practice. And look, that might not sound like the most exciting thing in the world, but here's why you should care. NCARB dedicates 20 to 26% of the entire PcM exam to this one module. That's more weight than any other topic area. So if you're going to invest your study time wisely, this is a really good place to start. We've got 26 slides across 6 sections, and I want to give you a quick roadmap so you know what's coming. Section 2.1 is all about why business operations matter in the first place. We'll look at why NCARB even tests this stuff, and how business failures can directly hurt the public. Section 2.2 covers business entity structures, sole proprietorships, partnerships, LLCs, S-corps, C-corps. Which ones actually protect you, and which ones leave you totally exposed. Section 2.3 dives into employment law, the federal laws every architect needs to know. Title VII, FLSA, ADA, FMLA, and workplace harassment rules. There's a lot here, and the thresholds matter. Section 2.4 is professional ethics. The AIA Code of Ethics, the 6 canons, and the specific rules of conduct that could put your license at risk if you get them wrong. Section 2.5 tackles standard of care, what good enough actually means in a legal sense, how it gets proven in court, and where claims really come from. And Section 2.6 wraps up with professional liability insurance, claims made versus occurrence policies, tail coverage, deductibles, and risk management strategies that actually work. Here's the thing. Each section builds on the one before it. By the end, you'll see how these 5 areas connect, and why a mistake in one area can quickly snowball into problems across all the others. So with that, let's jump into Section 2.1. Why business operations actually matter for the ARE. I didn't go to architecture school to learn about LLCs and overtime laws. If you've ever thought that, you're definitely not alone. But here's something most people don't realize until it's too late. More architecture careers end because of business mistakes than design mistakes. Firms don't go under because of ugly buildings. They go under because of cash flow problems. Licenses don't get revoked for bad facades. They get revoked for ethics violations. And personal bankruptcies? Those come from picking the wrong entity structure, not from structural engineering errors. So why does NCARB test this? Because the ARE exists to protect the public, and business failures directly harm the people you're supposed to serve. Think about it. A firm goes bankrupt mid-project, and that building just sits there, unfinished, while the owner loses their entire investment. No professional liability insurance? Injured parties have zero way to recover damages. Employment law violations, ethics breaches, wrong entity structure. Every single one of these creates real victims. Now, there are 5 pillars you really need to know for this module, and I want to walk you through each one. Business structure. Basically, if I get sued, can they take my house? Employment law. Am I paying people correctly and legally? Professional ethics. What am I required to do and what's off limits? Standard of care. What's legally good enough? And insurance. What's covered and what isn't? What makes this tricky, and honestly what makes it interesting, is that these 5 areas are all connected. An ethics violation can trigger an insurance claim, which exposes weaknesses in your entity structure, which leads to personal liability. One mistake sets off a chain reaction across all 5 pillars. And don't think this is only relevant if you're a principal or firm owner. Whether you're an intern who needs to understand basic ethics, a licensed architect who can now be personally liable, a project manager handling contracts and insurance certificates, or a principal with personal assets on the line, this knowledge matters at every stage of your career. You're not just studying for a test here. You're learning to protect yourself, your future firm, your employees, and the public. And that journey starts with the most fundamental decision any architect makes: how to structure your practice. Before we dive in, quick heads up for anyone taking the exam after April 27, 2026. The PcM objectives are changing. Objective 4.1 now asks you to identify and compare practice and business structures, not just understand them. So expect scenario-based questions like, given this situation, which entity type is best? Not just straight definitions. Keep that in mind as we go through these structures. All right, let's talk about sole proprietorships and general partnerships. These are the simplest business structures you can set up. And honestly, they're the riskiest ones for architects. A sole proprietorship means you are the business. There's no separation between you and it. Profits go straight on your personal tax return, Schedule C. A general partnership is just 2 or more people sharing a business, with each partner reporting their share on a K-1. Pretty straightforward so far. Simple to set up, easy taxes. But that simplicity comes at a huge cost. Both of these structures come with unlimited personal liability, and that's the critical thing you need to understand. Think about what that actually means in practice. A client sues for a design error, your house, your savings, your retirement fund, all at risk. The firm can't pay rent, the landlord can garnish your personal wages. An employee causes a car accident while on firm business, your personal assets pay the judgment. There's no wall between you and the business, so everything you own is fair game. And with partnerships, it actually gets even worse. In a general partnership, you're liable for your partner's mistakes too. This is called joint and several liability, and it's as scary as it sounds. Your partner signs a bad contract, you're personally liable for all of it. Your partner commits malpractice, you're personally liable. Your partner embezzles from a client, you're still personally liable for all of it. And a creditor can actually go after any single partner for the entire amount, not just their share. So if your partner has no assets, guess who pays everything? You do. When you really think about it, running a sole proprietorship or general partnership is basically a bet that nothing will ever go wrong. And for architects, where a single missed detail can lead to $1 million claim, that's not a bet I'd want to take. So if these structures are so risky, what do most architects actually use? That's what we'll cover next, the LLC, which is the structure about 80% of architecture firms choose, and for good reason. So the LLC was created back in the 1970s to combine the best features of corporations and partnerships. And it worked so well that it's now the most common structure for architecture firms by a wide margin. Let's look at why. Here's what an LLC gives you. Liability protection. Business debts can't touch your personal assets. Pass-through taxation. No double tax, profits flow directly to your personal return. Flexible management. You decide how to run things. No mandatory board meetings or corporate formalities. And simple formation. Just file articles of organization and create an operating agreement. That's it. Now let's see how that protection actually works in a real scenario, because this is where it really clicks. Say there's a $500,000 judgment against your firm, but the firm only has $100,000 in assets. In a sole proprietorship, the creditor takes the $100K from the firm, then comes after you for the remaining $400K. Your house, your savings, everything you've got. In an LLC, the creditor gets the $100K from the firm and that's it. Your personal assets stay protected. That's a massive difference. And it's exactly why the overwhelming majority of architecture firms go with the LLC. But, and this is really important for the exam, the LLC is not a magic shield. It doesn't protect you from everything. Here's where you need to pay attention. An LLC protects you from the firm's general debts, from your partner's mistakes, and from employee errors. But it does not protect you from your own professional negligence. It doesn't cover personal guarantees you've signed, and it definitely doesn't protect you from fraud or illegal acts. So you're still personally liable for your own malpractice. That's exactly what professional liability insurance is for. It picks up where the LLC leaves off. The LLC handles business debts and other people's mistakes, but your own professional errors? Those follow you no matter what entity structure you choose. Think of it this way. An LLC creates a separation. It keeps business problems from becoming personal problems, but your own professional mistakes remain your personal responsibility, regardless of what structure you're in. The LLC is the go-to for most firms, but some architects choose corporate structures instead. Let's look at S Corps and C Corps next, when they make sense, and the tax advantage that could save you thousands of dollars a year. Both S Corps and C Corps give you the same liability protection as an LLC. So why would anyone bother with them? It really comes down to two things: taxes and complexity. Let's start with the C Corp. A C corporation is its own separate tax entity. The corporation itself pays tax on its profits. Then, when shareholders receive dividends, they pay tax again on that same money. Same dollar, taxed twice. That's called double taxation, and yeah, it's expensive. So why would anyone choose this? Because C Corps can have unlimited shareholders. If you want to raise capital from lots of investors, or you're thinking about going public someday, the C Corp is the structure that makes that possible. For most small architecture firms, though, it's overkill. Now the S Corp. An S Corp gives you pass-through taxation, just like an LLC, no entity-level tax. But it comes with restrictions. Maximum 100 shareholders, only one class of stock, and shareholders have to be U.S. residents. You also need more formalities: a board of directors, regular meetings, documented minutes. More paperwork than an LLC, for sure. So what's the appeal? Tax savings, and potentially significant ones. Here's how it works with real numbers. Say your firm makes $300,000 in profit. In a standard LLC, all $300K is subject to self-employment tax at roughly 15%. That's about $45,000 right off the top. But in an S Corp, you pay yourself a reasonable salary, let's say $150,000, which is subject to payroll taxes. The remaining $150,000 comes to you as a distribution, with no self-employment tax attached. Your tax bill drops to about $23,000. That's roughly $22,000 in savings every single year, not nothing. But there's a catch, and this comes up on the exam. Your salary must be reasonable for your role. If comparable architects in your area earn $150K and you're paying yourself $50K just to dodge payroll taxes, the IRS will absolutely notice. That leads to audits, penalties, and back taxes. So when do you choose what? If you're simple and just starting out, go LLC. If you're profitable and want those tax savings, LLC with an S Corp election is the sweet spot. Need outside investors? C Corp. Going public someday? Definitely C Corp. Choosing the right entity structure is just the first step, though. You also have to maintain it properly, because that liability protection can actually disappear if you're not careful. Let's talk about how that happens. All right, so you've set up your LLC or corporation. You've got that liability shield in place. You're protected, right? Not always. Here's the thing. Just having an LLC on paper doesn't automatically guarantee protection. Courts can pierce the veil, that's the actual legal term, and hold you personally liable if you've been misusing the structure. Let me walk you through the behaviors that'll cost you your protection. Paying personal bills from the business account. That shows the entity isn't really separate from you. Skipping your operating agreement or bylaws. Now there's no evidence you ever set up a real formal structure. Never holding meetings or documenting decisions. Your entity starts looking like it only exists on paper. Underfunding the business so it can't handle foreseeable obligations. And here's one people miss. Signing contracts personally without noting your role. You write John Smith instead of John Smith, member of Smith Architects LLC. And suddenly, you're personally bound even though you didn't mean to be. But the single most common way architects lose their protection? Commingling funds. And it usually starts small. Here's how it typically plays out. Step 1. I'll just pay this personal expense from the business account. I'll reimburse it later. Step 2. That reimbursement never happens. Step 3. The pattern continues. Step 4. Business and personal finances get completely tangled up. Step 5. A lawsuit hits. Step 6. The creditor's attorney digs through your bank records and finds those mixed transactions. Step 7. The court says, you treated them as one entity, so will we. And Step 8. Your personal assets are fully exposed. Everything the LLC was supposed to protect is now on the table. This happens to real architects. It starts with one convenient transaction and ends with losing everything you've built. So how do you stay protected? Keep separate bank accounts. Always. No exceptions. When you sign anything, sign as Jane Smith, member of XYZ Architects LLC. That shows you're acting for the entity, not personally. Hold annual meeting minutes, even if it's just you in a room documenting decisions. Keep adequate capital in the business for your risk level. And keep your operating agreement on file and up to date. Here's the main takeaway. Your protection only works if you respect the separation. Treat the LLC as a separate person with its own money, its own decisions, and its own records. Because legally, that's exactly what it is. Now that we've covered business structures, let's shift gears to another area that catches architects off guard: employment law. We'll start with an overview of the federal laws every architecture firm needs to know. Here's a number worth remembering: $250,000. That's what a single employee misclassification case can cost an architecture firm. A harassment lawsuit can shatter your reputation overnight. And unlike professional liability claims, which your insurance covers, many employment violations come straight out of your own pocket. No policy to bail you out. Employment law mistakes can take down a firm faster than any design error. So let's make sure you know the landscape. I want to walk you through what I call the Big Four federal employment laws. Each one has a specific employee count threshold, and those thresholds matter a lot. Title VII prohibits discrimination based on race, color, religion, sex, and national origin. It kicks in at 15 or more employees. The ADA prohibits discrimination against qualified individuals with disabilities, also 15 or more. The ADEA protects workers 40 and older from age discrimination. That one starts at 20 employees. And FMLA provides job-protected leave for family and medical reasons, 50 or more employees within 75 miles. Now here's a simple way to lock those thresholds into your memory for the exam. 15, 15, 20, 50. Title VII is 15. ADA is 15. ADEA is 20. FMLA is 50. Say it a few times. 15, 15, 20, 50. And it'll stick. So why do these thresholds actually matter? Because a lot of small firm owners assume employment law doesn't apply to them. And that's almost always wrong. Sure, a 12-person firm isn't subject to federal Title VII, but it probably is subject to state equivalents with much lower thresholds. California's FEHA covers employers with just 5 employees. New York, 4 employees. So even if you're a tiny firm, you're not off the hook. Let's look at this breakdown by firm size because it really drives the point home. A firm with 5 to 14 employees is already subject to the FLSA and almost certainly state discrimination laws. Hit 15 employees and you add Title VII and the ADA. At 20, the ADEA kicks in. At 50, you're subject to everything, including FMLA. The bottom line here, I didn't know, is never a valid defense. Even when federal law doesn't apply to your specific firm size, state law almost certainly does. You need to know this stuff regardless. Let's go deeper into the most important of these laws, Title VII. Understanding Title VII gives you a foundation for most of the discrimination concepts you'll see on the exam. Title VII is the foundation of federal discrimination law. If you really understand Title VII, you'll have a solid handle on most discrimination concepts you'll see on the ARE and in practice. So let's dig in. There are 5 protected classes under Title VII, and I want to walk through each one because the details matter. Race. And this now includes hair texture and protective hairstyles, which is a relatively recent expansion. Color, which is actually separate from race. Complexion-based discrimination can happen within the same racial group. Religion, which includes not just a ban on discrimination, but also a duty to accommodate religious practices, unless it creates undue hardship for the employer. Sex, which covers gender, pregnancy, sexual harassment, and, since the 2020 Bostock decision, sexual orientation and gender identity as well. And national origin, country of origin, ancestry, even accent discrimination. You can't require English-only policies without a genuine business necessity. That Bostock ruling is definitely worth flagging for the exam. Since 2020, sexual orientation and gender identity are federally protected under Title VII's sex category. This is settled law now. It's not something that varies state by state anymore. Now, there are 4 types of discrimination you need to know. Disparate treatment is intentional, something like, we don't hire women for site work. Disparate impact is trickier. It's a neutral policy that ends up disproportionately affecting a protected group, like a height requirement that screens out women and certain ethnic groups, even though it seems neutral on its face. Harassment creates a hostile work environment based on a protected class. And retaliation means punishing someone for complaining about discrimination. Let's talk about retaliation, because this is honestly where firms get into the most trouble. Here's how it usually goes. An employee complains about discrimination. The complaint may or may not even have merit, but then the employer fires that employee. Now, even if the original discrimination complaint was weak, the employee sues for retaliation. And that retaliation claim is strong. The employer loses a case they might have actually won on the original issue. Retaliation is now the #1 charge filed with the EEOC. The most dangerous moment for any firm is right after an employee files a complaint. Any adverse action, termination, demotion, bad project assignments, can look like retaliation, even if you had legitimate reasons. The practical takeaway: document performance issues before complaints ever come up. If you wait until after someone files a complaint to start building a file on them, it looks retaliatory, even if those issues are completely real. From who's protected, let's move to who gets paid what. The Fair Labor Standards Act is where architecture firms make some of their most costly and most preventable mistakes. The FLSA requires overtime pay, time and a half, for every hour over 40 per week, unless the employee is exempt. And this is where architecture firms mess it up constantly. They assume that job titles determine whether someone is exempt. They don't, not even close. There are 3 tests for exemption, and here's the critical part. All 3 must be met. Miss even one, and the employee is non-exempt and owed overtime. First, the salary basis test. The employee has to receive a fixed, predetermined salary, not hourly pay that goes up and down. Second, the salary level test. They need to earn at least $684 per week, which works out to $35,568 per year. Fall below that threshold, and they're automatically non-exempt, no matter what their job looks like. And third, the duties test. Their primary duties have to qualify under a specific exemption category. This last one is where most firms trip up. A quick note on that salary threshold. The Department of Labor tried to raise it significantly in 2024, but the rule was struck down by a federal court in November 2024. As of early 2026, the the $684 per week number is still in effect, but this area keeps evolving, so verify the current number before your exam. There are three main exemption categories that matter for architecture firms. The professional exemption covers work requiring advanced knowledge and genuine discretion. Think a licensed architect making real design decisions. The executive exemption covers people who manage a department, supervise 2 or more full-time employees, and have actual input on hiring and firing decisions, like a studio director. And the administrative exemption covers office work involving discretion on significant business matters, maybe a marketing director setting firm strategy. But this one rarely applies to anyone doing design work. Let me give you an example that ties all of this together because it's the kind of scenario you'll see on the exam. Sarah has the title Project Architect. She earns $85,000 a year. She's got an architecture degree. Sounds exempt, right? Not necessarily. Look at what she actually does every day. 70% of her time, she's redlining drawings based on the principal's markups, basically following instructions. 20% of the time, she's updating Revit models to match sketches somebody handed her. And 10%, she attends meetings but rarely speaks up or makes decisions. Sarah follows instructions. She doesn't exercise independent judgment on significant matters. Despite her title and her salary, she may well be non-exempt and owed overtime for every single hour over 40 she's ever worked. That back pay liability adds up fast. The question isn't what's her title or what's her salary. It's what does she actually do every day? Duties determine everything. From overtime rules, let's move to disability accommodation. Next up, what the ADA actually requires when an employee has a disability, and what reasonable accommodation really looks like in an architecture firm. The ADA requires employers to provide reasonable accommodation to qualified employees with disabilities, unless it causes undue hardship. Now, those terms might sound vague, but they actually have pretty specific meanings, and you definitely need to know them for the exam. Let's break them down. A qualified individual is someone who can perform the essential job functions with or without accommodation. An architect who uses a wheelchair can still design buildings. The wheelchair doesn't change that. Essential functions are the core duties the job exists to perform. For a drafter, that's producing accurate drawings, not climbing ladders at job sites. Reasonable accommodation means changes that enable the person to do their work, things like a modified desk, screen reader software, or flexible hours for dialysis treatments. And undue hardship means significant difficulty or expense for this specific employer. And that's a key detail. What counts as undue for a 5-person firm is very different from what counts as undue for a 500-person firm. Context matters. Let's look at what this plays out like in a real architecture firm. A drafter develops carpal tunnel. You might provide an ergonomic keyboard, voice-to-text software, and a modified workstation. A project manager has an anxiety disorder, a private workspace, written feedback instead of verbal, and a predictable schedule could work really well. A designer uses a wheelchair, accessible workstation, and you need to honestly evaluate whether site visits are truly essential for that particular role. A staff member needs dialysis 3 times a week. Flexible scheduling and work-from-home options can make that work. But here's what a lot of people miss. Accommodation isn't about the employer guessing what might help. There's a specific process you're supposed to follow. It's called the interactive process, and it has 5 steps. 1. The employee requests accommodation, or the employer notices a need. 2. The employer asks, "What limitations do you have? What would help?" 3. Together, you identify options that work for both sides. 4. The employer chooses an effective accommodation. And here's an important detail. It doesn't have to be the employee's preferred option, just an effective one. 5. Document everything. Write it all down. Here's the practical takeaway that really matters. Employers who engage in this process in good faith rarely lose ADA cases, even if they ultimately can't accommodate the employee. But employers who refuse to even have the conversation, they almost always lose. The willingness to engage is what courts look at. One more thing for the exam. Your job descriptions should clearly identify essential functions before you ever need them for an accommodation situation. You can't suddenly claim site visits are essential when someone in a wheelchair applies if your last 3 employees in that role never actually did site visits. Courts will see right through that. We've now covered discrimination, overtime, and disability accommodation. Next, let's look at FMLA and what job-protected leave actually means for architecture firms, because it's one of the most commonly misunderstood laws out there. Picture this. Your lead project architect walks into your office and says, "I need 12 weeks off. My mother has cancer." And if your firm meets the requirements, you're legally required to grant that leave. No discussion. This is the Family and Medical Leave Act, and it's one of the most commonly misunderstood employment laws in architecture. Let's walk through how it actually works. FMLA applies to employers with 50+ employees total, with employee eligibility additionally requiring 50+ at the worksite within 75 miles. The employee needs at least 12 months on the job and 1,250 hours worked in the past year. If those conditions are met, they get up to 12 weeks of unpaid leave per year, with job protection. That means they come back to the same position, or an equivalent one. You can't demote them, you can't give their job away, you can't restructure them out. Now, notice I said unpaid. This is the single most common mistake people make with FMLA. They assume it means paid time off. It doesn't. The law protects their job, not their paycheck. Some employers choose to offer paid leave on top of FMLA, but that's entirely voluntary. FMLA itself is about job security, nothing more. So what actually qualifies for FMLA leave? Birth or adoption of a child, bonding time, a serious health condition, either yours or a close family member's, surgery, cancer treatment, chronic condition flare-ups, and military family leave, which can actually extend to 26 weeks when you're caring for an injured service member. Now let's talk about where firms get into real trouble, because these mistakes happen more than you'd think. You can't deny leave just because the timing is bad. We're in the middle of a deadline. Doesn't matter. That's a violation. You can't require the employee to find their own replacement before they leave. That's an illegal condition. You can't count FMLA leave against someone in their performance review. That's retaliation. And terminating someone while they're on FMLA? Courts will presume that's retaliation, and it's incredibly hard to defend against. One more thing worth knowing. If your firm has fewer than 50 employees, FMLA doesn't apply to you at the federal level. But state laws can be way more protective. California's CFRA kicks in at just 5 employees. New York's paid family leave covers all employers regardless of size. So don't assume you're exempt just because you're small. To wrap this up, FMLA is about job security, not a paycheck. Know the thresholds, know the qualifying reasons, and never punish someone for taking leave they're legally entitled to. Next, we'll look at another major area of legal exposure for architecture firms: workplace harassment, and what actually creates liability. Harassment claims can do real damage to architecture firms. And usually, it's not through massive jury verdicts. It's through reputational harm, key people leaving, and partnerships falling apart. So let's talk about what actually creates legal liability here, because this is an area where a lot of architects have misconceptions. The law recognizes 2 types of sexual harassment, and they carry very different consequences. First is quid pro quo. That's when a job benefit, a promotion, a raise, keeping your job, is tied to a sexual favor. If that happens, the employer has strict liability. There's no defense available, period. Second is hostile environment. This means severe or pervasive, unwelcome conduct that makes the workplace intolerable. But And this is important. Not every offensive comment creates legal liability. Courts look at several factors to make that call. How bad was each individual incident? How often did it happen? Was there any physical contact, or was it just words? Did it actually interfere with the person's ability to do their job? All of these get weighed together. A single crude joke probably isn't enough, but a pattern of crude jokes over months, combined with physical intimidation, that's a different story. Now, here's the part you really need to know for both the exam and practice: the employer defense. 2 Supreme Court cases, Ellerth and Farragher, established that employers can actually defend themselves against hostile environment claims if they meet 3 conditions. 1. You had a reasonable anti-harassment policy and you actually trained people on it. Not just a policy sitting in a drawer, real training. 2. You took prompt corrective action when you learned about an issue. 3. The victim unreasonably failed to use your complaint procedures. If you can show all 3, you've got a real defense. If you can't, you're probably liable. This is why harassment training isn't just a nice thing to do. It's legally valuable. Having a policy plus training shows reasonable care. Without them, you've got nothing to present to a court. It's the difference between having a defense and not having one. And let's be specific about architecture firm risks, because our industry has some unique vulnerabilities. No written harassment policy, that's extreme risk. Studio culture with casual or colorful language, high risk. Long hours plus alcohol in the office, elevated risk. Power dynamics between a principal and an intern, also elevated risk. These are exactly the situations where claims tend to come from. The bottom line is that prevention programs aren't just good practice, they're a legal asset. A solid policy and real training can be the difference between winning and losing a lawsuit. All right, with harassment covered, let's pull all of these employment law topics together into a practical compliance checklist. Most employment lawsuits don't come from dramatic events. They come from inconsistency. You fire one person for being late, but only warn another. You ask different interview questions depending on the candidate's gender. You document performance issues for some employees, but let others slide. That gap between how you treat different people, that's where lawsuits start. Firms that avoid employment claims don't just have good luck, they have good systems. So let's build yours. Start with documentation. You need written job descriptions before you post a position. These define essential functions and qualifications, which is critical for ADA compliance down the road. You need an employee handbook from day one of your firm, not something you'll get around to eventually. Offer letters at every hire. Performance reviews at least annually. And I mean real documented reviews, not casual conversations. I-9 forms within 3 days of hire. Not 3 weeks, 3 days. That's the law. And time records every pay period for all your non-exempt employees. Then there are required postings. Federal law says you have to display certain notices where employees can actually see them. The EEOC Know Your Rights poster. The FMLA notice if you've got 50 or more employees. The FLSA minimum wage poster. The OSHA safety poster. These aren't optional or nice to have. They're legal requirements. And yes, firms get cited for missing them. But honestly, the most important thing to take away from this entire employment law section is one word: consistency. Let me show you what inconsistency looks like in practice. If you fire a minority employee for tardiness, but only give a warning to a white employee for the same thing, that's evidence of discrimination. If you grant FMLA leave to one person, but deny it to another in the same situation, that's an FMLA violation. If you ask male candidates about their technical skills, but ask female candidates about their family plans, that's discrimination evidence a plaintiff's attorney will love. If you document performance issues for some people but not others, you've got a weak termination defense when you actually need one. The best employment law defense is honestly pretty boring. Consistent policies, consistently applied, consistently documented. Treat everyone the same way, write it all down, and most lawsuits never get filed in the first place. It's not glamorous, but it works. And that wraps up our employment law section. Next, we're shifting to professional ethics, starting with the structure of the AIA Code of Ethics, and why the difference between shall and should matters so much on the exam. The AIA Code of Ethics has a 3-tier structure, and it trips up a lot of exam candidates. Here's why. Most people don't understand the difference between what's enforceable, meaning you can actually be disciplined for violating it, and what's aspirational, meaning it's a goal to strive for, but there's no punishment for falling short. That distinction is everything on the exam. Let me walk you through the 3 tiers. At the top, you've got canons. These are broad principles, big picture statements about what architects should value. Things like serve the public interest or uphold the dignity of the profession. They're aspirational. You can't be disciplined for failing to perfectly live up to a canon. In the middle, you've got ethical standards. These sit under each canon and offer more specific guidance. They use the word should. Still aspirational, still not enforceable. Think of them as the roadmap for how to pursue the canon's ideals. At the bottom, and this is where it gets real, you've got rules of conduct. These are mandatory requirements. They use the word shall. Violate a rule of conduct and you face actual discipline. Your AIA membership can be suspended or revoked. These are the teeth of the code. The exam tests this distinction through language, so you need to pay close attention to the wording. When you see should, that means aspirational. Aim for it, but no punishment if you fall short. When you see shall, that means mandatory. Violate it and there are consequences. When you see shall not, that means prohibited. Do it and you face discipline. Let me show you how the 3 tiers work together with a concrete example, because this is exactly how the exam presents it. Canon 3 says architects should serve clients competently. That's the big idea, the aspiration. Ethical Standard 3.1 says architects should undertake work only if they're qualified. That's more specific guidance, but still aspirational. But Rule 3.101 says architects shall not undertake work beyond their competence without proper education, training, or engaging qualified consultants. That's the enforceable line. Cross it and you face real consequences. See the progression? The canon sets the goal. The ethical standard provides guidance. The rule draws the line you can't cross. So when the exam asks, which of these is required, look for a rule, not a canon or ethical standard. When a question describes behavior and asks if it's a violation, only rules can be violated. Falling short of a canon might be disappointing, but it's not punishable. Remember, shall equals mandatory equals enforceable. Should equals aspirational equals guidance only. This comes up again and again on the exam. Now that you understand the structure, let's look at what the 6 canons actually say and how their priority order works. There are 6 canons in the AIA Code of Ethics, and you need to know them well. Not just what each one covers, but how they rank when they conflict with each other. That's exactly how the exam tests them. They'll give you a scenario where 2 canons pull in different directions and ask you which one wins. Let's go through all 6. Canon 1. General obligations. Maintain your competence, stay current with the profession, understand the impact of your work on the community. Canon 2. Obligations to the public. This is the big one. Health, safety, and welfare. Comply with laws, civic responsibility. If you remember nothing else, remember this canon sits at the top. Canon 3. Obligations to the client. Be competent for the project you take on, manage conflicts of interest, maintain confidentiality. Canon 4. Obligations to the profession. Be honest, Don't bring the profession into disrepute. Mentor the next generation. Canon 5. Obligations to colleagues. Fair dealing. Recognize others' contributions. Show professional respect. Canon 6. Obligations to the environment. Sustainable design, conserve natural resources, consider environmental impact. Here's a memory trick to keep them in the right order. Generally, the public and clients expect professional colleagues to protect the environment. General, public, client, profession, colleagues, environment. That maps directly to Canons 1 through 6. Say it a couple times and it locks in. Now, the part that really matters for the exam is the priority hierarchy. When two canons conflict, which one wins? Public welfare is always first. Always. No exceptions. If a client wants you to skip fire exits to save money, you refuse. Canon 2. Public safety. Outranks Canon 3. Client interests. Every single time. Client interests come second. If you discover a colleague's error that affects your client, you disclose it. Client duty outranks colleague relations. Professional integrity is third. If a competitor offers you a kickback, you decline. Full stop. Colleague relations are fourth. If a colleague asks you to cover up a mistake, you refuse. Your professional integrity outranks the relationship. The environment, while important, sits at the bottom of the priority list when there's a conflict. If a client rejects green features for cost reasons, you advocate for sustainability, but ultimately you respect their decision. Let me show you how this plays out on the exam. A question says, a client demands the architect ignore a code violation to save money. What should the architect do? You identify the conflict. Code compliance is Canon 2, public safety. Client wishes are Canon 3, public wins, always. The answer is you refuse the client's demand and explain why. When the exam presents a conflict between canons, identify which ones are involved, apply the hierarchy, and remember that public safety beats everything else. Next, we'll look at the specific rules of conduct that show up most frequently on the exam, especially the ones around plan stamping and conflicts of interest. There are a lot of rules of conduct in the AIA Code, but certain ones show up on the exam over and over because they address the ethical situations architects actually face in practice. Here are the 3 you need to know best. Rule 2.101. You shall not knowingly violate the law. Sounds obvious, right? But the exam tests whether you'll compromise this when a client pressures you. Just skip the accessibility requirements. Nobody's going to check. That's a Rule 2.101 scenario. Rule 3.201. You shall not accept work where you have a conflict of interest without disclosing it. This tests your conflict of interest awareness and how you handle it. And Rule 4.102. You shall not sign or seal documents that were not prepared under your responsible control. This is plan stamping, and it's probably the most frequently tested rule in the entire code. Let's spend some time on it. Plan stamping is when you put your professional seal on drawings you didn't actually supervise or control. And the line between what's okay and what's a violation is really important to understand. If your staff prepared drawings under your direction and you reviewed them, that's responsible control. That's fine. If a consultant did work that you specified, coordinated, and verified, also fine. But if another firm produced drawings and you just briefly looked them over, that's plan stamping. If you signed drawings you never actually reviewed because you trust the architect who prepared them, that's prohibited. If someone offers you a fee just to put your stamp on their work with no meaningful involvement from you, that's the classic violation, and it's exactly what the exam tests. Responsible control means you directed the work and reviewed it. It means you specified what consultants should do and you verified their output. It means that if someone asks, "Why did you detail it this way?" you have a real answer based on your professional judgment. If you can't professionally vouch for every aspect of the documents, you don't have responsible control, and stamping them is a violation. Now let's look at Rule 3.201, Conflicts of Interest. You've got a financial interest in a contractor? Disclose it to the client in writing and get their consent before proceeding. A family member works for the developer? Disclose it and let the client decide whether they're comfortable. You're advising two competing clients? You may need to decline one engagement. You serve on a review board that's evaluating your own project? Recuse yourself. And here's the key takeaway that a lot of people miss. Having a conflict of interest is not unethical. Hiding a conflict, that's what's unethical. Most conflicts can be managed through one straightforward step: disclosure and informed consent. When in doubt, disclose. It's almost always the right answer. Next, we'll build a decision-making framework you can use on any ethics question the exam throws at you. Ethics questions on the ARE can feel tricky because the scenarios are designed to make you second-guess yourself. But here's the good news. With a systematic approach, these questions become way more manageable. I'm going to give you a 3-step framework that works on any ethics question, whether it's on the exam or a real situation in practice. Step 1. Identify the competing interests. Ask yourself 4 questions. What does the client want? That's the client interest. What protects public safety? That's the public interest. What preserves your professional integrity? That's the professional interest. And what's legal or illegal? Those are your legal boundaries. Map out all the interests at play before you even look at the answer choices. This is how you avoid getting tricked by a plausible-sounding wrong answer. Step 2. Apply the priority hierarchy we just learned. If public interest conflicts with client interest, public wins. If public conflicts with your profit motive, public wins. If client interests conflict with colleague relationships, client wins. And if something is illegal, legality wins against everything. You can't violate the law no matter who's asking or what the justification is. Step 3. Identify your available actions. You've basically got a menu of responses. Disclose and get consent. That's your go-to for conflicts of interest. Refuse and explain. That's for illegal or unsafe requests. Recuse yourself when you've got a direct personal stake in the outcome. Report to authorities when there's imminent danger to the public. And resign from the project when continued involvement just isn't tenable anymore. Let me walk through an actual example so you can see this framework in action. Your client asks you to specify a product manufactured by a company you own stock in. What do? Step 1. Competing interests. The client wants the best product for their project. You've got a financial interest in profiting from your stock ownership. Professional integrity demands objective recommendations. Step 2. This is a conflict of interest, which falls under Rule 3.201. No public safety issue, but there's a clear conflict between your financial interest and your duty to the client. Step 3. Your available actions. Disclose your ownership to the client. Let them decide with full information. If they consent and still want that product, you can proceed. Document the disclosure and the consent in writing. The answer: disclose the ownership interest and obtain informed consent before proceeding. That's it. You'll notice the pattern with ethics questions as you practice more of them. They almost always have one clearly correct answer, the one that prioritizes public safety, requires disclosure, or refuses an illegal request. If you're torn between 2 options, pick the more transparent one. Transparency is almost always the right call on the ARE. That covers our ethics section. Next, we're moving into a concept that's critical for both the exam and your career: the standard of care and what it actually means when someone claims you were negligent. When a client sues an architect, the claim is almost always negligence. And to prove negligence, they've got to show you breached something called the standard of care. This concept is fundamental both for passing the exam and for protecting your career. So let's make sure you really understand what it means. Here's the formal definition. The standard of care is the degree of care, skill, and diligence that a reasonably prudent architect would exercise in the same community, at the same time, under similar circumstances. Every single word in that definition matters. Let me break it down. Reasonably prudent means competent, not brilliant. You're being compared to your average peers, not to the star architects winning design awards. Nobody expects perfection. Same community means local context matters. Seismic design standards in California are way different from what's expected in Florida. You're judged against what architects in your area would do, not some universal standard. Same time means you're judged by the standards that existed when you did the work. A project designed in 2010 gets evaluated by 2010 standards, not today's codes and knowledge. That matters because standards evolve. Similar circumstances means the type and complexity of the project count. An architect designing a hospital is held to a different standard than one designing a storage warehouse. The stakes are different, so the expectations are different. Now let me clear up some common misconceptions, because these trip up both exam candidates and practicing architects all the time. Standard of care is not perfection. Architects can make errors and still meet the standard. That's an important distinction. It's not what the best architects would do. It's what average, competent architects would do. It's not defined by what the client expected. Professional peers define the standard, not clients. It's not zero errors. Some mistakes are reasonable, some aren't. And it's not a guarantee of a perfect outcome. Architects guarantee reasonable effort, not perfect results. Here's the actual test courts apply. They ask one question: would a reasonably competent architect in this area, at this time, on this type of project, have done what this architect did? If the answer is yes, no negligence, even if something went wrong. A roof can leak without anyone being negligent. If the detail used was reasonable and commonly accepted at the time, the architect met the standard of care even though the outcome was imperfect. If the answer is no, there might be negligence, but only if the other elements are also proven. That's an important distinction. A bad result doesn't automatically mean someone was negligent. Next, we'll look at what else a plaintiff needs to prove beyond the breach. They have to establish 4 separate elements of negligence, and if any one of them fails, the architect wins. Here's something that should actually make you feel a little better. To win a negligence lawsuit against you, the plaintiff has to prove all 4 elements, not 3 out of 4, not most of them, all 4. If any single element fails, the architect wins. So let's look at what they are. Element 1, duty. The plaintiff has to show you owed them a professional obligation. Typically, this comes from your contract. If you've got no contract and no professional relationship with the person suing you, there may be no duty at all. That's actually a valid defense in some cases. Element 2, breach. They've got to prove you failed to meet the standard of care. This is where expert testimony comes in. Another architect has to get on the stand and testify that what you did fell below what a reasonably competent architect would have done in the same situation. Element 3, causation. This is the big one, and it's where a lot of cases actually fall apart. The breach has to have caused the harm. Maybe you made an error in your design, but it was the contractor's sloppy installation that actually caused the building to fail. If your error didn't cause the damage, there's no causation and no case. Element 4, damages. There has to be real, quantifiable harm. Repair costs, injuries, lost revenue, something concrete. If there's a crack in the wall but no actual damage, it's cosmetic. Nobody's hurt, nothing's leaking. There may be no damages to recover. Now here's the useful part. Each element is also a potential defense strategy. No duty? We had no contract with this third party. We owed them nothing. No breach? Our detail was standard practice. Other architects use it routinely. No causation? Yes, we made an error in the documents, but the contractor's work is what actually caused the failure. No damages? There's a hairline crack, but it's purely cosmetic. No real harm occurred. Let me walk through a scenario so this all clicks together. An architect designs a building. The roof leaks. The owner sues. Let's check the elements. Duty, yes, the contract created a professional duty. Breach, did the roof detail meet the standard of care? That's going to require expert testimony from both sides. Causation, did the design cause the leak, or did the contractor install it incorrectly? This is often where the fight really is. Damages, yes, there's water damage and mold remediation costs, so that element is probably met. Here's the key point. If the detail was standard practice, meaning no breach, the architect wins despite the leak. Or if the contractor installed it wrong, meaning no causation, the architect also wins despite the leak. Something went wrong does not equal the architect was negligent. Plaintiffs have to prove all four, and defense attorneys look for the weakest link to challenge. That's how architectural malpractice defense actually works. Next, we'll look at how courts determine whether the standard of care was met, which brings us to expert testimony and why it really drives these cases. So how does a court actually decide whether you met the standard of care? Here's the thing. There's no checklist they pull out and compare your work against. No scorecard. Instead, standard of care is established through expert testimony. Architects testifying about what their peers would have done in the same situation. Here's how it actually plays out in a courtroom. The plaintiff brings in their expert architect, who says something like, "No competent architect would have done this. That detail was clearly inadequate." Then your side brings in an expert who says, "Actually, this detail is used throughout the industry. It's a perfectly reasonable approach." And then the jury, people who probably can't read a set of construction documents, has to decide which expert to believe. That's how it works. And that means the standard isn't fixed. Several factors can actually shift it up or down depending on your situation. Let's walk through these 5 factors. Geographic location matters. Seismic detailing in California is held to a higher bar than in Kansas. Project complexity matters. A hospital versus a storage shed carry very different expectations. And here's one that catches people. If you've claimed a specialization, you're held to specialist standards. Put healthcare design expert on your website, and you've just raised the bar for yourself, whether you meant to or not. The time period matters too. You're judged by the standards that existed when you did the work, not today's standards, and your contractual scope limits your duty. If you only agreed to do schematic design, you're not on the hook for construction administration issues. One more trend worth knowing about. The locality rule is fading. It used to be that you were judged against what architects in your specific town would do. But with the internet, national publications, and standardized codes becoming the norm, courts are increasingly applying national standards. Arguing that nobody in our small town does it that way is becoming a weaker and weaker defense over time. And here's something important that ties back to your everyday business decisions. Your own marketing materials can raise the standard applied to you. Advertise as a specialist, and you'll be held to specialist standards. Even if your work would have been perfectly fine by generalist standards, if you've been marketing yourself as an expert, courts will hold you to that higher bar. So be thoughtful about how you present your firm's capabilities. That wraps up our look at how standard of care is proven in court. Next, we'll examine where negligence claims actually come from, and the data might surprise you. It's not what most architects expect. Most architects picture negligence claims as dramatic events, a building collapse, a catastrophic roof failure, but the actual data from insurance companies tells a very different story. Most claims are honestly pretty mundane, and the vast majority of them are preventable. Let's look at the numbers. About 40% of claims come from design deficiencies. And we're not talking about bold creative choices gone wrong. We're talking about coordination errors, missed code requirements, and constructability problems. 30% come from contract administration, failing to catch problems during construction, making improper certifications, not doing enough site visits. 20% are communication failures, unclear documents, decisions that nobody bothered to write down. And the remaining 10% are disputes over fees and scope. Now let's get specific about what actually triggers these claims. Water infiltration is one of the biggest. It's where multiple building systems meet and the interfaces get complicated. If your wall-to-roof transition or your window details aren't coordinated properly, water finds a way in. Structural and MEP conflicts happen when your consultants work in their own silos without coordinating. The ductwork runs right through the structural beam because nobody checked. Code compliance errors come from copying details off old projects without verifying they still meet current codes. Specification errors follow the same pattern, copy-paste without careful review. And CA oversights happen when firms just don't budget enough time for site visits and field observation. But the real common thread behind most of these claims? Communication breakdowns. A verbal agreement that never got documented becomes, "I never agreed to that." An RFI answered by phone leaves no record of your direction. A scope change discussed over lunch but never put in writing turns into a billing dispute. A client decision that wasn't captured in a follow-up email becomes, "You designed it wrong." Here's the key takeaway from all this data, and it's one worth really internalizing. It's not the most complex projects that generate the most claims. It's the worst documented ones. Good paperwork prevents lawsuits more effectively than good design. That confirming email you send after a phone call? From a risk management perspective, it's more valuable than the time you spend perfecting a detail. Now that we've seen what goes wrong, let's talk about how you protect yourself financially when it does. Next up, professional liability insurance, starting with the different types of policies every architecture firm needs. Welcome to Section 2.6, Professional Liability Insurance. This is basically the financial safety net between your firm and serious financial trouble. And the first thing you need to understand is that no single insurance policy covers everything. You need multiple policies, and you need to know what each one actually does. Let's start with the 3 essential policies every architecture firm needs. These are non-negotiable. First, professional liability, also called errors and omissions, or E&O. This covers errors in your professional services. If a client sues claiming your design caused a leak or a code violation, this is the policy that responds. Second, general liability. This covers bodily injury and property damage from your general operations. Someone trips over cables in your office, for example. Third, workers' compensation. This covers your employees if they're injured at work, like a staff member who falls during a site visit. Now here's something the exam absolutely loves to test, so pay attention. General liability specifically excludes professional services. Your general liability policy will not cover you if someone gets hurt because of your design work. That's a critical gap. Think about it this way with some real scenarios. If your design error causes a structural failure, that's professional liability. If someone trips in your office lobby, that's general liability. If your employee drops equipment on someone at a job site, general liability. But if you miss a code requirement and it leads to an injury, that's professional liability again. You need both policies because each one covers a completely different type of risk, and neither one fills the other's gap. A lot of architects think, "I've got insurance, I'm covered." But they don't realize their general liability specifically excludes the types of claims most likely to hit an architecture firm, claims arising from their professional work. That gap is where firms get into real trouble. There are other policies worth knowing about too. Employment practices liability insurance handles discrimination and wrongful termination claims. Cyber insurance covers data breaches. And yes, architecture firms hold sensitive client data. Property insurance protects your equipment and office contents. Business auto covers firm vehicles, and umbrella policies provide excess coverage over your other policies. But the big 3, professional liability, general liability, and workers' comp, those are the ones you absolutely must have. Now that you know the types of policies out there, let's tackle the most commonly misunderstood concept in professional insurance: the difference between claims made and occurrence policies. This is heavily tested on the exam. If there's one insurance concept that trips up architects on the exam and in real life, it's the difference between claims made and occurrence policies. So let's break this down clearly. An occurrence policy is triggered by when the incident happens. A claims made policy is triggered by when the claim is filed. That's the core difference. Sounds simple enough, but the implications are huge. Let me walk you through an example that makes it click. You design a building in 2020. A defect in your design causes damage that isn't discovered until 2025. The claim gets filed in 2025. If you had an occurrence policy in 2020, you're covered, because the incident occurred during the policy period, even though the claim came 5 years later. Your old policy still responds. But if you had a claims-made policy only in 2020 and then let it lapse, you're not covered, because you don't have a policy in force when the claim is actually made in 2025. However, and this is key, if you've maintained continuous claims-made coverage from 2020 through 2025, you are covered, because the claim is made during an active policy period. Here's why this distinction matters so much for architects specifically. General liability uses occurrence policies. You're covered based on when the incident happens. But professional liability uses claims-made policies. You need coverage not just when you do the work, but also whenever a claim eventually arrives. And that could be years later. A construction defect might not show up for 3, 5, even 10 years after the building is finished. There are 3 key terms you should know for the exam. The retroactive date. Claims for work done before this date aren't covered by your current policy. Prior acts coverage. This extends your protection backward to work you did before the current policy started. And tail coverage, also called an extended reporting period. This lets you report claims after your policy ends. The main point here is straightforward. With claims-made policies, you need coverage when the claim arrives, not just when you did the work. If you let your coverage lapse at any point, every project you've ever worked on becomes uninsured overnight. That's why continuous coverage is so critical. Any gap can be devastating. That retroactive date we just mentioned, it's actually one of the trickiest parts of professional insurance. Let's look at how it can create gaps in your coverage without you even realizing it. The retroactive date. It sounds like a minor policy detail, but it's actually one of the most important terms in your professional liability policy. Your policy only covers claims for work performed on or after the retroactive date. Anything you did before that date? Not covered. Let me show you how this works with 3 scenarios. Say your retroactive date is January 1st, 2015. You did work in March 2018, and a claim is filed in June 2024. You're covered. The work was done after your retroactive date, and you have a current policy. But same retroactive date, January 1st, 2015, and the work was done in December 2012. Claim filed in 2024. You're not covered. The work was done before your retroactive date, so your policy won't respond. Now here's where it gets tricky. What if your retroactive date moved forward to January 1st, 2020? That work you did in March 2018, which was covered under the old retroactive date, is now uncovered. Even though you have an active policy, even though you're paying premiums. So how do architects accidentally create these gaps? There are 4 common ways. First, switching insurers. Your new insurer sets a fresh retroactive date, and suddenly all your previous work is uninsured. Second, letting your policy lapse and then renewing. The renewed policy may come with a new retroactive date. Third, firm mergers. The new entity's policy may not cover the old firm's work. And fourth, retiring without tail coverage. When the claim arrives years later, there's no policy to respond. Here's what matters most from this slide, for both the exam and your career. When you're comparing insurance policies, the retroactive date is more important than the premium. A cheaper policy with a fresh retroactive date leaves years of your work uninsured. You could save a few $1,000s on premiums and expose yourself to hundreds of thousands in liability. Always negotiate to keep your original retroactive date when switching carriers. So what happens when you stop practicing altogether? That's where tail coverage comes in, and it might be the most important policy decision you ever make. Tail coverage, formerly called the extended reporting period. This is the insurance you buy when you retire, close your firm, or switch insurers without prior acts coverage. It's your last line of defense for everything you've ever designed. Here's how it works. Without tail coverage, your claims-made policy ends and you have no coverage for any of your past work. A claim arrives 2 years after you retire, you pay out of pocket. With tail coverage, you have an extended window to report claims, so your past work is still covered even though you're no longer practicing. A claim arrives 2 years after retirement, the insurance pays. Why is tail coverage necessary? Because professional liability claims often show up years after you finish a project. Construction defects might appear in 2 to 3 years. Building envelope failures and water infiltration, 5 to 7 years. Structural issues and latent defects, 10 years or more. If you designed a building in 2020 and retired in 2025, claims from that project could arrive in 2028, 2030, or even later. Without tail coverage, you're personally exposed. Let's talk about cost, because this is where people get surprised. Tail coverage typically costs 150 to 200% of your last annual premium as a one-time payment. So if you're paying $15,000 a year, your tail might cost around $26,250, paid once. Why so much? Because the insurer is taking on open-ended risk with no future premium income from you. But compare that $26,250 to the alternative. One uninsured claim could easily exceed $500,000 in personal exposure. In that light, the tail coverage is a bargain. When do you need tail? If you're retiring permanently, yes, essential. Closing your firm, yes, essential. Switching to an insurer who won't cover your prior acts, yes, buy tail from your old insurer. Selling your firm where the new owner assumes liability, maybe, but negotiate carefully. Taking an extended leave but planning to return? No, just maintain continuous coverage. Bottom line, tail coverage is expensive, but it's your last professional expense and one of the most important. It protects your retirement savings against claims that may arrive years after you've stopped practicing. Next, let's look at what's actually inside your policy: deductibles, limits, and a structure called defense inside limits that can leave you with less coverage than you think. You have insurance, but do you know how much protection it actually provides? Because policies have limits and structures that affect your real-world coverage in ways that aren't always obvious. And there's one structure in particular that catches architects off guard. Let's start with the key terms. Your per-claim deductible is what you pay out of pocket before insurance kicks in. A $10,000 deductible means you're covering the first 10 grand of every claim. Your per-claim limit is the maximum the insurer will pay for any single claim. A $1 million limit means that's the ceiling, regardless of actual damages. Your annual aggregate is the maximum total payout across all claims in a given year. Hit that number, and you're effectively uninsured for the rest of the year. And defense costs. Attorney fees, expert witnesses, court costs can easily exceed $100,000 on their own. Now here's the part the exam loves to test. It's called defense inside limits versus defense outside limits. With defense inside limits, your legal defense costs eat into your coverage limit. So if you have a $1 million limit and your defense costs $300,000, you only have $700,000 left for any settlement or judgment. With defense outside limits, your $1 million is preserved entirely for the settlement, and defense costs are paid separately. Let me walk through an example. You have a $1 million per claim limit with defense inside limits. A $600,000 claim is filed against you. Your defense costs through trial run $500,000. That leaves only $500,000 of your limit for the settlement. But the judgment comes back at $600,000. You're now personally on the hook for $100,000. If you'd had defense outside limits, the full $1 million would have been available for that judgment, and you'd have been fully covered. So what should you look for when comparing policies? Defense outside limits is better than inside. A higher aggregate protects you from multiple claims in 1 year. A reasonable deductible, not so high that you're essentially self-insuring. And an insurer with an AM Best A rating, not an unknown carrier. The key takeaway: don't just look at the premium when comparing policies. Ask about defense inside or outside and check the aggregate. A cheap policy with defense inside limits and a low aggregate may leave you badly exposed when you need it most. We've covered what can go wrong and how insurance protects you. Now, let's talk about something even better: preventing claims from happening in the first place. Every experienced architect eventually learns this. The best insurance is not needing to use it. Good risk management prevents claims before they happen and strengthens your defense when they do. And it doesn't require any special tools or expensive systems. It just requires discipline. Let's start with documentation, because it is your single best defense. Every verbal agreement with a client, confirm it in an email within 24 hours. Every client decision on a design direction, get written approval with a date. Every site observation, take photos and write a report. Every RFI response, keep copies with dates. Every scope discussion, distribute meeting minutes. These aren't busy work tasks. They're the evidence that saves you when someone says, "I never agreed to that," or "You designed it wrong." There's a simple habit that can make a real difference. Call it the 24-hour rule. After any important conversation with a client, a contractor, a consultant, send a confirming email that says, "Per our conversation today, we agreed that X. Please let me know if this doesn't match your understanding." That one sentence, sent consistently, has protected countless architects from disputes. If the other party doesn't respond, courts typically treat your summary as an accurate record of the conversation. Beyond documentation, quality control practices prevent the design errors that generate claims. Peer review before milestones. Fresh eyes catch coordination errors you've gone blind to. A code compliance checklist for every project. Systematic review prevents missed requirements. Constructability review identifies details that look good on screen but can't actually be built. Specification cross-checks catch conflicts between your specs and your drawings. And CA observation logs that document site conditions. Finally, your contracts themselves are a risk management tool. A limitation of liability clause caps your exposure. A mutual waiver of consequential damages protects both parties. A clear scope definition prevents, "I thought that was included." A dispute resolution clause controls how disagreements play out, and timely notification requirements mean the client has to tell you about problems promptly. Good paperwork prevents lawsuits more effectively than good design. The time you invest in documentation and quality control is the best risk management money can buy. That wraps up Section 2.6 on professional liability insurance. Now let's bring everything together with a summary of Module 1. Let's bring it all together. You've just worked through the entire foundational layer of Practice Management Module 1, Business Operations and Organizational Structures. That's a lot of material, so let's recap what you've learned and why it matters. We started with Section 2.1, Why Business Operations Matter. The main idea is that architecture is both a profession and a business. Firms don't fail because of bad design. They fail because of bad business decisions. Every design decision has a financial consequence, and understanding that relationship is what separates firms that thrive from firms that close. Section 2.2 covered business entity structures, sole proprietorships, general partnerships, LLCs, S corporations, and C corporations. The key concept is liability protection. Sole proprietors and general partners put their personal assets on the line. LLCs and corporations create a legal shield between the business and your personal wealth. The entity you choose determines who's at risk when something goes wrong. Section 2.3 covered employment law, Title VII, the Fair Labor Standards Act, ADA, FMLA, and harassment law. The key takeaway is that ignorance is not a defense. These laws apply whether you've read them or not, and the thresholds matter. Title VII kicks in at 15 employees, FMLA at 50. Know the numbers. Section 2.4 was professional ethics, the AIA Code of Ethics, the 6 Canons, and the rules of conduct. Ethics isn't abstract for architects. The rules of conduct are enforceable. Violate them, and you face real disciplinary action from the AIA. Your obligations run to the public, your clients, the profession, your colleagues, and the environment. Section 2.5 introduced standard of care, not perfection, but what a reasonably prudent architect would do in similar circumstances. We looked at how it's proven through expert testimony, what factors shift the standard, and where claims actually come from. 40% of claims come from design deficiencies, and poor documentation is the common thread in almost all of them. And Section 2.6, professional liability insurance, claims made versus occurrence. The retroactive date trap, tail coverage, defense inside versus outside limits, and risk management practices, documentation, the 24-hour rule, quality control checklists, and protective contract provisions. This section is heavily tested on the ARE, so make sure you know it well. The thread connecting all 6 sections is this. Architecture isn't just about design. It's about running a legally protected, ethically grounded, financially sound, and properly insured practice. Understanding that will help you on the ARE and throughout your career. Your next step is the Foundational Check Quiz. 15 questions that test your understanding of everything we've covered. Don't worry if you don't get every question right the first time. The quiz is a learning tool, and the explanations will help strengthen any areas where you're less confident. Once you're through it, you'll be ready to move into the advanced concepts. You've built a solid foundation. Time to put it to the test.